You're driving home late at night when you get pulled over. Blue lights flashing in your mirror, you watch the officers walk toward your car. After you stop, the cop holds out a small device. Blow, he says, and you think to yourself, what happens if I refuse the breathalyzer? Driving under the influence of alcohol is illegal everywhere in the world. First, you need to know that. Here is how things work in the United States. At any time of day, if an officer approaches your car for an alcohol test, you are expected to comply. So what are the legal limits? The general limit across the United States, the standard limit in all 50 states, is 0.08% blood alcohol content. Special limits include commercial vehicle drivers at 0.04%, which is stricter. Drivers under 21 years old face zero tolerance in most states, meaning 0.00 to 0.02%. And in some states, an impaired driving charge can be filed at 0.05% if the evidence is strong enough. And in that moment, this thought crosses your mind. But if I don't give them evidence, maybe I can get off. If I refuse, maybe I can get away with it. This thought crosses the minds of thousands of people every year. Most people reason like this. No test, no evidence. No evidence, no charge. It sounds logical, but this idea falls apart right here. Because in the United States, driving a vehicle is like signing a silent contract. The moment you got your driver's license, you also agreed to something else, even if you were not aware of it. In legal terms, this is called implied consent. It means you are considered to have agreed even if you never said so. Every state has this law. 50 states, 50 different rule sets, and you are included in all of them. But they all share one thing in common. The day you got your license, if you were ever stopped on suspicion of driving under the influence, you are considered to have already consented to a breath test. Nobody told you this. They did not ask about it at your driving exam, but it was in the form you signed. You can refuse, yes. Technically, you can say no. Nobody can physically force you to blow into that device, but that choice absolutely comes with a price. And that price carries consequences far heavier than most people expect. First consequence, your license is immediately suspended. The officer writes up a document, takes your original license from you, and gives you a temporary paper. No need to even wait for a court ruling. Depending on the state, this suspension period typically starts at 1 year. And this is not in case you are found guilty. It is simply because you refused. Understanding that two processes move forward at the same time is critical. One is the state's administrative action regarding your driver's license. The other is your driving under the influence case in criminal court. One does not have to wait for the other. Second consequence, refusing does not protect you. The officer can still arrest you. There are the results of the field sobriety tests performed on the roadside. There are observations, your eyes, your speech, your balance issues. These all count as evidence. Third consequence, your refusal itself can be used against you in court. The United States Supreme Court stated in 1983 that a person's refusal to take a breath test can be used against them in court. The logic in the jury's mind works like this. Why did they refuse? Because they knew what would happen if they blew and were found guilty. However, there is an important exception here. Some states, like Georgia and Massachusetts, do not allow this refusal to be used as evidence in court due to their own state constitutions. So this rule can vary depending on the state you live in. And blood tests are a separate story. In 2016, the Supreme Court drew a clear line. The state can criminalize someone who refuses a breath test, but someone who refuses a blood test? No. A blood test is more invasive. It requires a warrant. Sticking a needle into someone's body is a different matter. However, a detective can call a judge within minutes and get that warrant. Then the police can take your blood, whether you want it or not. Knowing your rights does not make the decision easier, but it lets you know what to expect. Now let's look at real life. People refuse and think without a test, they can't prove it. Wrong, because the vast majority of people who refuse still end up convicted. The officer documented everything that night. Your driving, your speech, your eyes, your unsteadiness. And those notes are used against you as evidence in court. There's also this. Many states have launched no-refusal programs. Especially during holiday weekends, officers are on call alongside on-duty judges. If you refuse, a warrant arrives within 15 minutes, and a blood test is administered immediately. While you think you are winning by refusing, you are actually only dragging out the process. What about unconscious drivers? Someone who gets into an accident and wakes up in a hospital. In 2019, the Supreme Court said if a driver is unconscious and a breath test cannot be performed, police can, in most circumstances, take a blood test without a warrant. There is not even time to say, "Let me refuse." And there is this myth: the Fifth Amendment protects me. I don't have to testify against myself. Wrong. Blowing into a breathalyzer or refusing to blow is not considered testimony. It is a physical act. According to the Supreme Court, the Fifth Amendment does not apply here. Knowing your rights matters, but making decisions based on myths is a different thing entirely. The biggest mistake is thinking that refusal is a quiet victory. In most situations, it is simply a choice that multiplies the cost. Sometimes the most dangerous thing is not knowing nothing at all. It is knowing the wrong thing. Your rights only protect you when you understand them correctly. And the most important thing you need to know: if you call a taxi after drinking, you will have made the best decision for both your own safety and the safety of others. You may never need this information one day, but the day you do, you will remember that you watched this video. Subscribe to Rights Illustrated, because the law favors those who know it.